The judiciary is a vital arm of government, the protector of the laws that govern the land. Without it, the other arms of government would operate unchecked, leaving citizens vulnerable to abuse and injustice. Yet, in Nigeria today, a silent crisis gnaws at the very foundation of justice. The reality of awaiting trial syndrome, a situation where thousands of individuals languish in correctional facilities without ever being convicted or sometimes even formally charged with a crime. Year after year, many remain behind bars, caught in an endless cycle of delay and despair. Statistics reveal a harrowing truth. Over 70% of inmates across Nigerian correctional facilities are currently awaiting trial. The numbers are alarming, but beyond the statistics are human beings' lives interrupted and dreams deferred. The young man at the center of our story is one such victim. His case is particularly heartbreaking. Not only was he imprisoned without trial for years, but he was also innocent of the crime he was accused of. A patriotic neighbor, trying to break up a fight between two men, suddenly found himself entangled in a burden he neither deserved or anticipated. His simple act of intervention spiraled into 5 years of suffering behind bars.
On a very fateful day, I was coming back from work and I saw two people fighting. I went to separate them and the other man ran away. I saw the other man and he was very seriously wounded. I now took him to the hospital. Very unfortunately, the man died.
When the Chief Justice of Nigeria, Justice Kudirat Motonmori Kekere Ekun, assumed office, she took a strong stand against the abuse of court processes. She vowed to correct the wrongs of the past, committing to correcting flawed court orders and administrative lapses.
Let us therefore work collectively and tirelessly to ensure that Nigeria continues to abide by the rule of law, upholds the best democratic practices, and remains vigilant in the protection of her citizens' rights. No doubt, the effective administration of justice has always been a pivotal concern in our legal landscape, and recent efforts to modernize the system are crucial in addressing its persistent challenges. Central to these efforts is the enactment of the Administration of Criminal Justice Act, ACJA of 2015, which has been domesticated in various states in Nigeria. However, despite its potential to modernize the administration of justice in the criminal justice sector, key provisions remain underutilized and its full impact has yet to be realized. One major area of concern is the recurrent practice of arraigning suspects in court without proper preliminary investigations. In many cases, efforts to gather evidence are only initiated after trial has begun. This backward approach to criminal prosecution significantly delays the process and undermines the delivery of justice. It is unacceptable that in 2024, we continue to see such practices which contribute to the overwhelming backlog of cases in our courts and ultimately erode public confidence in the justice system.
Legal analysts and experts welcomed her resolve, but argued that true reform must confront the menace of awaiting trial syndrome head-on. Yet, the situation remains bleak, and every day, more individuals fall into the trap. The man in our story who chooses to remain anonymous recounted the harrowing details of his ordeal. For 5 long years, he endured psychological and emotional torture inside the rooms of Kuje Correctional Facility in the FCT. He spoke of the suffocating conditions, the overcrowded cells, scarcity of basic needs, and the health complications that came with being crammed into a space meant for far fewer people.
They arrested me. They took me to prison. I spent 5 years in prison. Things were rough, overcrowded, 30 to 35 persons in one cell. No water, no food. Things were so hard.
His story, however painful, is just one among thousands, especially among young Nigerians trapped in correctional facilities across the nation. Barrister Ibrahim Wali, a legal expert and a passionate advocate against awaiting trial syndrome, faults the slow pace of judicial processes and Nigeria's rigid bureaucratic systems for this ongoing tragedy.
It combined, I'll tell you a few stories. There's this young boy, Usama, was arrested in Katsina State, was brought here in FCT. He has been in detention since 2023. He has been in Kuje since 2023, and they are yet to even finish his case. And mind you, he pleaded guilty to the offense, but they are yet to actually review his fact. He fell ill. He almost died. I think it was diarrhea at the time, or not diarrhea. Sorry, it was TB, tuberculosis, and we had to find a way to get the court to give an order to transfer him from the detention center to a medical facility before we were able to take care of his health. But he's still awaiting trial. There's another person here, Rubella. He has actually lost his mind. We also got the court, got the prison center, got the court to make an order for the prison center to send in his medical certificate so that we can get some sort of bail for him. And there's this guy, Lanzema. His dad passed away while he was awaiting trial last year, and his wife passed away last week. I was part of those who had to inform him of that, and it was very, very emotional. And all these guys are still awaiting trial. Not even a single witness have been called in terms of the trial. So it's not even as if their trial is almost finished. They are at the beginning. So it has serious mental health, and physical problems for them. Really, it has all sorts of problems. There's a man who has 6 kids, Adebo Ishelo. He has 6 kids. 2 of them passed away while he was in detention. I think he has lost his mind as well, but he's recovering, because we were able to intervene, and try to calm it down. All sorts of things. There's a young boy, Fahad, a very young boy who was, his was even a petty offense, a very, very petty crime that ought to have, been settled by maybe a non-custodial, yes, but he has been there, and he picked up drugs. Can you imagine that? He picked up drugs inside. He started doing drugs. Now he's a druggie inside the correctional facility. So it does everything but rehabilitate, and in fact, you don't talk about rehabilitation because the program for rehabilitation, as inefficient as it is for convicted inmates, not for awaiting trials. But you get awaiting trials within 1, 2, 3, 4, 5, 6 years, 12 years. I know Moses, 12 years now, they're still on his case. They have not finished his case because the evidence is light. The officers involved in the investigation are nowhere to be found, and the court it's just adjourned de novo, and it's just there, and there's no lawyer pushing it for him. And if you want to do it, you have to start tracking these people and and that's another thing entirely, because the system is so slow, the bureaucracy is so slow, it just gets on your nerve. It's very unfortunate. It's very unfortunate. I also remember Faith Hassan. She was awaiting trial for almost 2 years. Her grandmother died. By the time we were able to get her out, she didn't have anybody again to go to.
Meanwhile, in an exclusive interview with ADBN, the Controller of Corrections, Francis Okonkwo for Akwa Ibom State, described the syndrome as a heavy burden on the correctional system. He explained that facilities designed to house 600 inmates often hold far more, largely due to the swelling population of those awaiting trial.
Yeah, because it's a huge frustration on the penal management, because imagine a situation where, the capacity of your prison, like you here, the capacity is 613, 613. That's the maximum number of inmates based on available facilities. But here we have a solid situation of over 1,890 as of today. So you can imagine the huge difference. When the population you are supposed to manage is very far from what you have, it leads to congestion and can even consequently bring about health issues.
All right,
While he acknowledged efforts between the judiciary and correctional centers to address the issue, he admitted that much more needs to be done to stem the tide.
Of course, we're always in synergy, we're always collaborating, and one of such collaborations played out from 12th to 14th of March this year, when the Honorable Chief Judge, His Lordship, the Kaite Fabian, graciously paid visit to all our formations, and in the process reviewed cases, and then granted release to over 50 inmates, and equally gave very liberal bail conditions for some of the inmates that were being held. And as we speak now, some of those ones, I'm sure they have facilitated their processes and they are free citizens now.
Okay.
So she has done that for us, and it was due to our collaboration with her office and the Criminal Justice Monitoring Committee that facilitated the process. So.
For the young man in our story, freedom, when it finally came, was bittersweet. After 5 years, he emerged into a world that had long moved on without him. There was no pause, no safety net to help him restart his life. The psychological scars ran deep, a stark reminder of the hidden costs of awaiting trial.
So, after they realized that I am innocent, they took me to court, and they have come to realize that I'm an innocent, and now they free me to go. So when I came back, I lost everything. My wife, my relationship, everything I lost. Nothing left behind. That was how I spent my life in prison.
Legal experts like Ibrahim Wali lament that this reintegration struggle is the painful reality for many wrongfully detained individuals. A society that expects them to simply pick up the pieces without offering support.
They should only go to court when they have to go to court, when they are ready to go to court. And obviously there is the problem with the Department of Public Prosecution under the Ministry of Justice, another complicit player, or rather another major stakeholder that is complicit in the current decay. Usually they have to interact with the police, they have to advise the police and give them advice on whether some cases should be charged or not. They have the overall prosecutorial powers in Nigeria under the Ministry of Justice. So they have not been able to streamline their communications with these LEAs. These LEAs act as if they don't even exist, and I don't think that they also want to actually bridge that gap. But if the Ministry of Justice and law enforcement agencies can have a cohesive some sort of symphony, some sort of symmetry, already you're solving about 50% of the problems. Now we don't have to go to courts now. Courts and its ministers, that is lawyers. So obviously the courts, you have to start from the composition, the constitution, the number of courts, the number of justices, the appointments, the employment. So you have to reform the entire judiciary. The judiciary as it is too understaffed, is too overblown, overbloated for the matters we have in Nigeria today.
Yeah, we are all human beings, and we are bound to be affected one way or the other, especially for those of them who feel that they are being unjustly incarcerated, because there are many who may not actually have committed the offense that brought them, due to maybe case of mistaken identity, or even case of outright wickedness. So people seem to have the withdrawal syndrome when they know they are being unjustly treated and all of that. But we have experts, clinical psychologists in our employ that deal with such situations, and they are responding to treatment.
While the Chief Justice of Nigeria's commitment to correcting judicial errors is commendable, there remains an urgent need to fast-track trials, uphold accountability, and protect the fundamental rights of inmates. The principle, of innocent until proven guilty must not only be a slogan, it must be a reality for all Nigerians, including those behind bars.
ACJA, however, provides solutions to some of these problems if fully implemented. For instance, Section 15, subsection 4 mandates that a suspect's extrajudicial statement must be made in the presence of a legal practitioner of the suspect's choice, or where the suspect is unable to secure one, in the presence of an officer of the Legal Aid Council. Additionally, the Act requires that the entire process be video recorded. These provisions are designed to ensure transparency and fairness in the treatment of suspects, reducing the risk of coerced confessions or procedural abuses. Unfortunately, many law enforcement agencies and prosecutorial bodies have not yet embraced these critical safeguards. The failure to adapt these measures exacerbates delays and inefficiencies, resulting in prolonged detentions and frequent adjournments due to inadequate evidence. Full compliance with these provisions of the ACJA would not only streamline the investigative and prosecutorial process, but also enhance the credibility and integrity of the criminal justice system. The effective implementation of the ACJA and ACJLs in the states must be prioritized. Law enforcement agencies, prosecutors, and judicial officers need to be properly trained and equipped to adhere to the requirements of the Act. In addition, mechanisms for accountability must be established to ensure compliance with these provisions. Beyond the ACJA, other critical aspects of our criminal justice system, including reforms in policing, the legal process, and the protection of individual rights, must be pursued with urgency and determination. These reforms are essential to creating a more efficient, transparent, and just criminal justice system that reflects the needs of a modern society. It is my intention to strengthen our processes, provide speedy and qualitative administration of justice, reinforce our structures from the Supreme Court to other courts of record, and reduce corruption to the barest minimum in the system. The Code of Conduct for judicial officers will be strictly enforced. Similarly, the requisite ethical standards will be expected of the Bar. Staff of the judiciary will also be expected to strictly comply with the Code of Conduct applicable to them. I must reiterate that the task of cleaning the audience table is a collective one, and my commitment to it is unwavering. I assure you that I will pursue it vigorously.
The time to act is now. The Nigerian judiciary owes a sacred duty to ensure that justice is not delayed and that the dignity of every citizen convicted or awaiting trial is upheld. Only then can we truly decongest our prisons, restore hope to the broken, and rebuild a justice system worthy of trust.